Welcome to the podcast. Thank you for joining. In full disclosure, we went to law school together.
Yeah.
And in some ways, I'm a little bit jealous of you because growing up, especially in television and movies, when you talk about lawyer, it's usually not like a trust and wills lawyer. It's usually the criminal lawyer. That's the really cool lawyer.
Yeah.
My first job was at a criminal defense firm when I was in law school. That's the route you went. And so I wanted to have you just tell us a little bit about what you did, your time at the public defender's office.
Yeah. 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 Like you said, we went to law school together many years ago. What was it, like almost like 15 years ago at this point. And when I went to law school, I did not think I was going to go into criminal defense. I thought I was going to be an entertainment lawyer. I love movies. I love show business. I was like, I'm going to be that type of lawyer. And I took classes in that area. But when it came time for on-campus interviews, I applied to a bunch of places, and the only place that accepted an interview with me was the LA County Public Defender's Office. So I'm like, I guess I'll interview here. And I got all dressed up. I was so excited. People were talking about all their interviews, and I was like, well, I've got one interview, but I'm excited about it. And of course, they didn't show up. So I felt like I was all dressed up with nowhere to go. It was like kind of embarrassing. And I ended up calling them. I'm like, hey guys, what's the deal? You guys left me hanging. And they're like, oh, we're so sorry. We're so sorry. So set up a new interview, ended up getting the clerkship job. And once I started working there, something clicked. It was a combination of the type of people that are doing this work are my type of people. And it was also, there was a feeling of urgency, of importance, and high stakes in criminal defense that I didn't feel in other areas of law. You're dealing with someone's freedom. You're dealing with whether or not that person's going to lose their job, lose their family, sometimes spend the rest of their life in prison. And I don't know if it's just the way my brain works, but that high stakes reality kind of kicks my brain into gear and makes me work harder. And this is for me, it makes me work harder than I've ever worked in anything I've ever done. And so I realized then that that's what I wanted to do. And I started with the public defender's office back in 2012. And I was with that office for 13 years. I did like everything under the sun. I worked in misdemeanors. I worked representing juveniles. And then I did a number of years in felony practice, handling everything from murders to sex crimes to, shooting, domestic violence. And then I ended my career as the deputy in charge of the East LA juvenile branch, where I supervised and mentored and trained a number of very talented juvenile practice lawyers, public defenders. And that was incredibly rewarding. Ultimately, I love the public defender's office. They've done so much for me, and I appreciate everything that I've gotten from the office. But it came to a point where it was there's no teleworking. So I was at the office all day, and I have two young children, a 5-year-old and a 2-year-old. And I was seeing them for about like 45 minutes a day. And I was just realizing that I just wasn't spending time with them, and I was watching them grow up, and I'm like, I'm missing out on all this. So in my mind, I'm like, well, I'm working all day, but I'm not necessarily making the kind of paycheck where I can go and take them on fancy vacations and buy a big house with a yard for them, or get them in a neighborhood with a good school district. So I kind of felt like I was like failing them on both fronts, And so as difficult as it was to leave that job and leave that kind of work, I decided, I think it would be better for me to enter private practice. Additionally, I hate to say it, but the public defender's office is suffering from a great deal of attrition right now. A lot of people are leaving. And when you are a big law office and people are leaving and they aren't being replaced, or they aren't being replaced with attorneys that can handle your work, then you end up shouldering the burden of everyone else's cases. And that can kind of be like a snowball effect. And so I was getting to a point where I realized I could not also practice the type of law that I wanted to practice. I think every single criminal defendant deserves a full Cadillac defense on every case. Doesn't mean you do things that are unnecessary, but it means that if there's a stone that needs to be turned, you need to go and turn it. And if you're working under high caseloads and you don't have time to do that, well, then I feel like that does not make me feel like an effective lawyer. And that's part of the reason I could also see in the future of that's not kind of where I want to keep practicing. So I entered
Right.
private practice. That's where I am now. Yeah.
And how long have you been in private practice now?
3 weeks.
So very new.
Yeah. Very new. Very new. It's a whole different world, man. A whole different world.
Starting in the beginning, you get thrown like the smaller cases. Sometimes you're looking at a case and you're like, why am I even on this? I'm a lawyer. You know what I mean?
Yeah.
And going all the way up to like some of the more serious cases. What was like one of the smallest or silliest cases where you looked at yourself and you're like, what am I even doing here?
Man. So I will tell you, I would get jazzed about the small cases, and I'll tell you why. Because in felony practice, you can understand why someone's being charged with murder. You can understand why someone's being charged with a shooting. And if someone says, "Hey, that person needs to go to prison," you can understand why the DA is asking for that, right? You don't say, "Hey, society's broken. Why are we trying to put murderers in prison?" No one's saying that, right? But with those low-level misdemeanor crimes, they're facing jail. That's what a misdemeanor is. It's up to 1 year in county jail. And so that's the kind of stuff that I'm like, I cannot believe you're trying to put this guy in jail or on probation for this stupid crime. And so I actually would get very excited about it. So you talk about one of the smallest cases I had. There was a period of time where the city attorney's office in LA was prosecuting bandit taxi cabs. So what's a bandit taxi cab? It's basically a taxi cab or someone who's acting as a taxi cab who is not properly licensed by one of the 9, I think it was, franchise taxi cab companies. Now, this was an awkward time, like before there was Lyft and Uber, but it was just starting to
Mm.
open up. So people were just starting to use Uber. And so what we would get was like a lot of these cases where the LAPD was setting up these like kind of sting operations to try and catch bandit taxi cabs, but they kept catching like Uber drivers. And it was so crazy because we would have these people come into court and be like, "Hey, I know the police report is saying that I offered to just take cash for giving them a ride, but that's not what happened at all. What happened was I was there and he was asking if I do Uber, and I said, yeah, but you have to go through the app. And we kept having it back and forth. And then he tried to get in my car. And then once he tried to get in my car, police came and arrested me. And I'm like, wow, okay, that's a huge difference. And so one of the big cases that I call it big, but it was big to me. One of the cases that I took to trial was a case just like this. And in preparing for the trial, I started to realize something. These LAPD officers that were doing this sting were a part of a special unit. And this special unit was getting paid overtime, regardless of how many hours they worked. Their hourly rate was overtime to do this special unit. Now think about it. You're getting paid a lot of money. Where is the money coming from? It's being paid for by the franchise taxi cab companies. So the companies that are standing to lose a lot of money from Uber and Lyft coming into existence are paying for LAPD to have a special task force to stop bandit taxi cabs. Well, of course, there's now an incentive for them to catch Uber and Lyft drivers. And that's what they did.
Mm.
And so they caught these Uber and Lyft drivers, and these poor guys, and a lot of them, their English was not that good. And, they were caught up in the system. They're barely making ends meet. And so, I took one of those cases to trial. I told that story. I made a big deal because LAPD doesn't record those conversations. So they're alleging, hey, he tried to exchange money for a ride. My client's alleging, no, that didn't happen. Wouldn't it be nice if there was a recording? Made a huge deal of that in trial. And I remember one of my favorite wins was on such a small case, a bandit taxi cab case, but it was on a case like that. 20 minutes. The jury went back into the room. They deliberated for 20 minutes and came out laughing, not guilty verdict. So, that's a
Wow.
case that'll always stick with me. So you say small case, but the small cases jazz me up too.
So you're talking about a period of time then, like when Uber and Lyft were just entering the mainstream. They're not really there yet. There was all those issues they had with like the CPUC and like all these regulations and things like that. What was the crime they were charging these Uber and Lyft drivers with?
It's like a municipal crime related to operating a taxi cab without proper licensure.
And what kind of
So
penalties like were they facing?
up to 180 days in county jail.
No
So
way.
they can be on probation for anywhere for up to 3 or 5 years at that time, and they could do up to 180 days in county jail. In fact, there was one case where it was in the news. This guy had kept getting prosecuted for those crimes. He kept kept getting picked up, and ultimately the judge was so upset he gave the guy 180 days in county jail. Now, mind you, I was representing domestic violence defendants who were getting 60 days in county jail, and this guy who's driving a taxi cab is getting 180 days in county jail. It was quite the perversion of justice, and it really really upset us and a lot of the people in our office.
Interesting. And then, so that was like on the smaller side, but like on some of the larger cases you worked on.
You always say the two types of cases that are high stakes are any case where the client is innocent and any case where the client is facing life in prison. My highest stake case was a murder case where my client, I believed, and he believed, that he was innocent. And so that was by far one of my most difficult, stressful cases because you feel the incredible responsibility of telling this person's story and navigating a trial in a way that hopefully will convince the jury that this person is not guilty of murder. And to make matters worse, my client was like very high anxiety. And so he didn't want to waive time. And what waiving time means is oftentimes in a serious case where you're facing life, it could take a year, 2 years to do the proper preparation in a case like this. And that client, he was not waiving time. And so we had just kind of short, I think 3 months to get prepared for the trial. And it doesn't sound like a lot, but when you talk about subpoenaing records and waiting for those subpoenas to arrive and interviewing witnesses and waiting for the district attorney's office to hand over evidence, 3 months is really not that much time.
Mhm.
And so that was, I think, one of the most difficult cases that I've done. And it's a case that sticks with me. And I can talk about the case if you want to hear about it.
Yeah, tell me about it.
Yeah, yeah. So basically, what happened was my client, and was all on video presented at trial. My client is walking down the neighborhood. He's homeless. He's walking down the neighborhood in I think it's like South LA area, and he has his bike, and you can see him on video. Everything's on video now, by the way. Everyone's got a video camera. He's on video. He puts his bike outside of like a kind of small bodega type shop. We're in LA, they're not really bodegas, but that's the kind of vibe of the shop. And he goes inside. Literally, as he's inside, seconds later, some guy comes, gets on his bike, and rides away. And so his bike got stolen. Literally, and you're watching the whole thing. It's like, wow. He comes out, and you can see he's like, oh, dude, what happened to my bike? What happened to my bike? And so he's kind of like stressed out. He's upset. And he's kind of like he goes into another shop next door, and you don't see what happened, but basically what he testifies to is that he says, hey, did anyone steal my bike? There happens to be another man in there who gets angered by this because he thinks that my client is accusing him of stealing his bike, right? That's the kind of theory that he's accusing him of stealing his bike. He starts saying, I didn't steal your fucking bike. He kind of gets in his face, and my client's like, hey, I'm not accusing you. Relax. And he kind of like taps his pocket to say like, I have a weapon, so you don't need to get close to me. He had a knife in his pocket, like a big butcher knife. He was like cutting a cantaloupe earlier in the day. And so what ended up happening was like, this guy starts getting mad. I think when my client's like, hey, back up, I have a knife, this guy took it as another like aggressive act. And he runs and pushes my client outside of the store. You see them tussling. You see them come out of the doorway in the camera. They're tussling. And then he's pushing my client, pushing him towards the street. A huge bus is coming. And so my client, takes out a knife and gives him like 3 to his abdomen. As soon as the guy gets struck, he kind of backs off. My client backs off. And then the guy runs 2 blocks, passes out, and passes away. They charged him with first-degree murder. They were not giving any offers, and we were not asking for any offers. My client wanted his day in court. He was saying I was defending myself. The whole challenge with that trial was that I had to when you're doing self-defense, it matters subjectively what the defendant is thinking at the time, that they were acting not in anger, but in preservation, for self-preservation. And so I had to make sure that I was able to tell my client's story, that he was able to tell his own story on the stand. And to make matters worse, there was a witness that said that my client punched the guy. The guy fell on the ground. While he was on the ground, my client got his backpack, took a knife out of his backpack, and then started stabbing him while he was on the ground, and then ran away. So you notice the first version I told is a little different than the second version I told, right? So what ended up happening was this woman just remembered it differently. She had like seen a traumatizing event, and she's like, I think this is how it went down. And that could have been the nail in the coffin because, her version of the story doesn't sound like self-defense. It doesn't sound like you're preserving your own life if someone's incapacitated on the ground and then you stab them. So it was a really big problem for us. And so I had to pour through all these video surveillance cameras in the area. And I ultimately found one that showed exactly what happened, and it contradicted her entire story. Had we not had that camera, he'd be sitting in a prison cell right now. And so, we were able to highlight that to the jury. My client told his story. He said, I felt myself getting pushed into the street. I saw the bus coming. I knew it was either me or him. And I remember I remember sitting, waiting for the verdict. The jury came back with the verdict. My client was like shaking. He was so scared. And when we heard the words not guilty, he just burst into tears. He just started sobbing. And that was one of the most powerful emotional like trial results, trial victories that I've ever experienced. And I'll never forget that. That client, this was 5 years ago, and that client still contacts me to this day. And he'll say, "Hey," he contacted me 3 months ago. He's like, "Hey, it's coming up on the 5 year anniversary of like this
Wow.
thing." Yeah, yeah, yeah. He was so grateful. And he really didn't trust the system. He had been in the system for a long time. And so he was just really appreciative and really happy. He's grateful that he's not in a prison cell right.
Right.
Yeah.
And so that's pretty crazy. I mean, you're talking about like a split second thing, that kind of random, very random thing that just happened, and all of a sudden you're charged with like first degree murder.
Yeah. Yeah. And it's like a lot of people don't realize that, you and I, if we had a disagreement at a coffee shop, it's probably not going to end like that. But when you're talking about two people who are probably homeless and who are living in survival mode and at every given moment, the way they interact with each other is very, very different. If I see you in a coffee shop, I'm not worried is Paymon gonna shiv me and take my money, right? But kind of like when you're homeless, like you're existing in this like fight or flight all the time. And I think that's kind of was the genesis of how this kind of happened over something so small. But it just goes to show you how quickly things can change on the street and
So the
become
other
really
guy was homeless too?
yes.
I see. Yeah. I mean, they probably deal with so much traumas and violence and so many things that like they kind of have to be on edge because anything could probably be a threat to them.
Yeah.
Um,
And I would say part of the reason they might be homeless is because they have such bad trauma and PTSD that they're living a very volatile life, and it makes it difficult to keep a job, to pay rent, a regular rent, and all the other things that are required to exist in this society.
and I think like the part of, as I was listening to your story, I was always thinking like, how would a jury take this? Like hearing that your guy had a machete because he was cutting cantaloupes earlier. That's a part that stood out to me as like, is that really? And these are some of the challenges I guess you have in a lot of your cases. Is like kind of slipping in some facts in there that are kind of a little bit. You're not sure how the jury's going to take that, or what was your thinking on that? Like,
You're
is a jury
first
going
of
to?
all,
Yeah.
Y so sorry to interrupt you. Yeah, you're absolutely right. That was a big bad fact. Why are you carrying around a huge it's like a butcher knife, not a machete, but like still
Right.
like abnormally big, right? And my client like swore up and down. He's like, I use it to cut cantaloupes. Like that was my breakfast for the morning. And it doesn't sound real, but I ended up finding a witness. Okay. He actually was taking classes in a local community college. I found a witness that said that earlier that morning he saw my client in the parking lot cutting a cantaloupe with that knife.
Kidding.
Yeah, and I presented that evidence. So it's like one of those things, like it's almost perfect, right? Because that's a really difficult fact, but now you have an uninterested third party who's like, I saw this thing. And
Right.
this is why investigation is so important, right? Because as much as there's a presumption of innocence, the jurors all are looking at your client saying there's a reason he's here, and it's
Right.
because he did something.
Right, and I guess one of the things that you said in this one is you actually put him on the stand, which, I know a lot of times in criminal defense, you don't put your guy on the stand. How did you decide, like, "Hey, I'm gonna put this guy on the stand," rather than just rest after the prosecutor's case?
So I'll tell you this, man. I understand that is what a lot of people hear. Don't put your client on the stand. I've done this for like 13, 14 years. Most of my trial wins happen when I put my client on the stand. Now, of course, I'm talking to my client beforehand and doing an assessment of whether this person, should be on the stand or would help themselves on the stand. When you put someone on the stand, that's oftentimes the last thing the jury hears before they go on to deliberate, right? Because the defense is presenting their case second after the prosecution, and they typically present all their evidence before they put their client on the stand. So it's the last thing. So it's really like, you do like a 1 week, a 2 week, a 3 week trial, and you'll have an emotional alleged victim. You'll have some emotional, strong evidence by the prosecution, days 2, 3, and 4, and then weeks of some boring stuff. And then the client testifies. And it's always emotional because they've been sitting there and everyone's been saying their truth at him. And now he finally gets to, or she finally gets to tell their truth. And the jury's hanging on every word, and they go in and deliberate, and that's what they remember. So I actually think it's incredibly powerful to be able to have a client testify. The problem is not everyone is articulate. Not everyone can, not even when you're innocent, there's certain speech patterns, there's certain like nervousness that can come off as you being untruthful. But you'll be surprised. People generally get a really good sense when someone's telling the truth, despite all that. And I think that can be very powerful for a jury. Yeah.
Right. As a non-criminal lawyer, and even before I went to law school, I always thought like if I were a juror and the person didn't take the stand, there's like some sort of presumption I would have like, hey, if I was accused of something I didn't do, I'd want to take the stand. And I know working at the criminal defense firm I was at, that was a big concern for a lot of defendants was like, I have to go on the stand because if I don't, they're going to think I'm guilty. And there were times where it didn't make sense to put the person on the stand. It just, there's more damage that could come out. Because in a lot of these cases, it's like, even if the person was innocent in the limited experience I had as a law clerk, like there was enough circumstances that led up to this point where they're being charged with something. It wasn't like completely disconnected. It was a little bit more nuanced than that. And so the risk of being cross-examined by the prosecutor just outweighed this person taking the stand. And I remember it was such a big deal that you had to like get things signed where you had like basically told the client that like, I advise you against taking the stand. You decided to take the stand regardless, you know? And did you ever have a case where you did advise someone not to take the stand and you took it all the way to verdict? And did you feel like that helped or didn't help?
So, yes, I did. I had a case where the client he was charged with like a sex crime against his daughter, but it was like a 20-year-old crime, and they were able to file it because of a statute of limitations issue, and that was a hard case. No one loves those cases. But that client really wanted to testify, and I said, "No, I don't think you should. I think we should, to rest on what we should argue based on the holes that we poke in their story." And we didn't win that trial, but it was a hang. And as you probably know, because you worked in a criminal defense firm, a hang, you live to fight another day. And
What
ultimately
does
the
a
case.
hang mean? It means
Well,
hung
yeah,
jury.
sorry. It means that, so, in criminal, you have to have a unanimous verdict. 12 jurors have to agree. When all the jurors don't agree, that means the jurors are hung and they cannot come to a decision, and the judge declares a mistrial, and you start the process for another trial. So in that trial, there was 10 people that wanted to convict and 2 people that did not. And there was a lot of issues with the age of the case, and I think those 2 people had a big problem with that. But ultimately, I know that if he was allowed to testify, I think those 2 people would probably have no problem convicting. It's a decision that is so case dependent, and it's person dependent too. It's person dependent too. I oftentimes think about, I don't know why I think about this, but I'm like, what would I be like as a
I thought
defendant?
about that too. Yeah.
I'm like, I think about some of my clients, and these are like salt of the earth people. They're so genuine, and they're so like, there's a sincerity to them that like I think really shines through. And then I think of myself, I'm like, people will probably think that I'm trying to be too smart. People will think I'm trying to like outsmart the process, and they probably wouldn't trust me. So it's so interesting. Like, it really is person dependent. Like, I don't think I would testify well, you know? So that happens too with certain police officers. They're so overcoached, and I always like to highlight how overcoached they are, that they come off like insincere and like they're hiding something. So it really,
Which is crazy because you're really articulate, but you're thinking that might even work against you.
yeah, man, because I don't know. I think so. I think that I always feel like I sound like I'm like trying to persuade, and that's why I like doing my job. But if you're in the defense chair and you're in the witness stand and you're trying to be that persuasive, it feels like I don't know. I would worry that it feels like I'm trying to hide something.
It
This
looks
is a
suspicious.
hypothetical.
You think that
Yeah.
it's suspicious. Like
Yeah. What do you think? Do you think you'd be a good witness?
I was a witness in a civil case. This was a personal injury matter. Really random how I ended up being a witness. Basically, I was just a brand new lawyer. And in personal injury cases, you have these things called IMEs, independent medical exams. We call them defense medical exams, where basically the defense gets to have your client go see a doctor. And a lot of times, unfortunately, either through malice or through just bad memory, the doctor misdocuments what actually happened at these at these exams. And so one of the things firms do is they send someone there with a recorder to record what's happening. So that was my job. I mean, that was one of the things I did there. So I went to this one exam, recorded it, thought nothing of it. Most of the time, nothing really comes out of it. You're just kind of there to make sure everything's, they're not asking questions they're not supposed to ask, and things like that. And I ended up, going to a different firm. And years later, I got called by that prior firm because that doctor, there was a civil rights case, and that it was somebody who had been severely injured while in the men's central jail. And there was allegations that the police were somehow involved in that. And in any event, the doctor, I guess, in that federal case in downtown Los Angeles took the stand and began accusing the client of refused to let me examine his leg and different things like that.
Wow.
And so they called me and they said, "Hey, according to the notes, you were there. Do you have that recording?" And this was years after. And I went on my laptop and I still had the recording from that meeting. So I had to come there to lay the foundation to get the recording in. So randomly, the next day I'm in federal court in downtown, and it's a lawyer that's doing direct on me. And I remember thinking exactly what you're saying, which is like the problem I think with being a lawyer is you know where things are going and you know how things are being framed. And so you're not just like the regular person that hears a question, you're just answering without thinking. You're almost overthinking,
Yeah.
and then you're answering things that were not asked because you're trying to block certain things from going certain directions. You're being truthful. You're being completely truthful,
Yeah.
but you just know what's going on. And so you're not allowing lawyers, for example, to put words in your mouth, or you're not allowing them to, the smallest misstatement you're correcting. At least for me, that's what it felt like. And I definitely feel like when I was testifying, I was being completely truthful. And I did feel like, stop overthinking, stop overthinking. Like,
Yeah.
I was even thinking of, should I be looking at the jury? Should I be looking at the lawyer? Should I be looking down? And so I don't know what kind of witness I would make. I've thought about that a lot, especially sitting in some criminal trial. Actually, the reason I really thought about that is there was a criminal case, was a murder case where I was a law clerk on. And one of the big arguments in that case, a defendant wanted to take the stand and the lawyer didn't want him to take the stand. I remember just thinking to myself, like, would I want to take the stand? I think honestly, like, there's a part of you where naturally you're like, listen, if I'm innocent, I want to take the stand. I'm innocent. Then there's the other part of you that's like, well, I understand things can happen and things can come off the wrong way. And maybe there are things that I don't have the best answers for. Maybe, you know what I mean? And
Yeah.
so, but I think ultimately I'm not in that situation, but I feel like I would want to take the stand and let the chips fall where they may. I think for my personality type, I would feel like whatever happens, happens. I'm gonna tell my side. And
Yeah.
I thought it'd be really cool to walk through some of that stuff for like everyday people. Just starting with like probably what everybody has dealt with, which is a traffic stop, right? You get pulled over, and usually like the cop's question is, "Do you know why I pulled you over?" What do you answer to that question?
Yeah. So look, do you know why I pulled you over? Might as well be, will you give me evidence of consciousness of guilt? Give me evidence that I can use against you. And especially a lot of officers nowadays are wearing body worn camera. So, that's being recorded. Whatever you say is being recorded. As a lawyer, I would never answer that question, you know, and how you not answer that question is really up to you, because the reality is that police are not always trying to get in confrontational. Sometimes they'll get confrontational, be like, I'm asserting my right to remain silent. I'm not answering it. And, and the police don't realize is like, okay, I'm about to deal with a jerk. Right. And so their defenses go up too. And so, from practical standpoint, do you want that? From a legal standpoint, never answer that question. You don't want to give them evidence. And frankly, you could say something like, you tell me, officer, I don't know. They may ask you other questions beyond that. And depending on what they ask, you can say, I'm not going to be answering any questions. Let me know, what would you like me to do?
Right.
Because once they pull you over, the assumption is that they had reasonable suspicion to pull you over, which is the legal standard. They could be wrong, right? They could have manufactured it, but it's not for you to litigate in that moment. It's for if they find something or a crime ends up coming about because of it, then your lawyer can litigate that in court. But in that moment, you're not going to litigate that. So once they have a reason to stop you, there's a few things that you have to do. You have to, if you're driving, you have to show them your license and registration. But you don't have to answer any questions. If you don't mind, like, I want to speak within the context of a specific type of pullover. Like, let's assume a
Yeah.
DUI. Okay. Let's assume you just had like a beer, just one beer, and you got into the car You don't feel the effects of the alcohol and you start driving. And maybe for whatever reason, you're missing a tail light, police pull you over. Okay. You roll down the window. They say, hey, you're missing a tail light. But then now the police smells alcohol. All right. So they think, okay, there's enough now for me to begin a DUI investigation because I suspect this person might be under the influence. What they'll always write in their police report is I smelled odor of alcohol. They had red, watery eyes. Their speech was slurred, and so that made me realize, okay, I need to initiate a DUI investigation. So at that point, if they think that they have those things, they can ask you to get out of the car and they can ask you to do, a field sobriety test, which involves, eye exam, walking a straight line. I can go into the details, but I don't want to bore your viewers. But essentially, everything that goes into a field sobriety test. And so you can say, no, thanks. I'm not going to do that field sobriety test. There's no law that requires you to do a field sobriety test. With respect to all the other stuff, you may know, you may have just had one beer, but he doesn't know how many beers you had. He just smells alcohol.
Right.
At that point, he can give you a breathalyzer exam. He has in the field, he has a little pass device. We call it preliminary alcohol screening device. And he can ask you to blow in it. And unless you're on probation or, under 21, you do not have to blow in that device. Now, if you were to blow in that device, it would give you like a number, 0.08, 0.09. The legal limit is 0.08. But even that result is not evidence that they need to show that you're driving under the influence. It's just enough to give them probable cause to arrest you, take you to the station, and give you either a blood test or a more reliable breath test. So
can you refuse that too?
If you refuse, you could. You could refuse the blood test or the breath test, but if you do, California law says that you get an automatic 1-year license suspension. And if the officer ultimately presents your case to a prosecutorial agency and they file a DUI against you, then you would not only have that DUI, but there's an enhancement to the DUI that they can allege that would increase the punishment because you refused a chemical test.
When you're out on the field, the only two tests they can really do is the field sobriety test, where they, have you walk, do the hand thing, and then the breathalyzer test. And then I guess you're saying if you refuse that, then you go down to the station, and that's where someone draws your blood. If you refuse any of those, there's this automatic enhancement, or how does that work?
No. What the law says is if you refuse a chemical test, okay? And so the chemical test only refers to that blood test at the station, or there's what's called an ECIR, which is like a more advanced, more sensitive breath test that they don't have. It's not a mobile test. And so that is also considered a chemical test. So you can't refuse those. You can refuse the pass assuming you're not on probation for a DUI or anything else, and you can refuse the field sobriety test. And oftentimes what I'd advise is, why are you giving them evidence? Why are you giving them preliminary evidence? You don't have to. You only have to give them the other evidence, which is the one at the station. So if they feel they have enough to say that you're driving under the influence just based on the way you're talking or the way you smell like alcohol, then let them take you to the station, and then you can give the breath or give the blood there. And, we always recommend blood because the big thing about blood is that they have to keep some of your blood. They test some of your blood and they keep the rest of your blood. And you can test that. A defense attorney later who gets hired on the case can retest that in a different laboratory to see if there was any issues with the laboratory testing that the police used. So there's a lot more options in how to kind of like defend DUI when someone takes the blood.
If you get arrested for DUI, is that happening no matter what?
Yes, it is. If they feel like they have probable cause that you're driving under the influence, they want one of the two, blood test or the breath test at the station. They give you the choice. And I guess sometimes they probably prefer it if you take the breath because you get the result right away. There's no retesting. It's harder to challenge those machines. There's ways to do it, right? You can look at calibration logs and you can see if that particular machine has artificially increases the amount just depending on its calibration, but they don't kind of prefer one or the other unless they think you are under the influence of drugs. And if they think you're under the influence of drugs, well, then they want you to take that blood test and they can ask you to take that blood test.
And if you refuse everything, I mean, I assume you're probably getting arrested. What was this enhancement you're talking about?
Yeah. So in addition to there's two things going on in any DUI case. There's what the DMV does and what the prosecution does. Okay. You can get prosecuted by a crime, and then the DMV, doing its own thing, can also suspend your license. So when you refuse, the DMV will do an automatic suspension of your license for a year. In addition, if you get charged with a DUI, they use an enhancement allegation to have you serve more time in jail if you get convicted of that DUI and the enhancement. So,
Got it.
they're basically making it to deter you from refusing, right? I've seen a lot of cases on refusals where the stop was because of a checkpoint, a DUI checkpoint. So the police have not really observed any driving patterns, and maybe they smelled alcohol and they said there was like slurred speech, but then the person rejects the field sobriety test, rejects the preliminary alcohol screening test, and then they deem that there's enough evidence to arrest them and take them to the station, and they refuse the chemical test. And so the officers are kind of scrambling to be able to use any and all observations to say, hey, even though we didn't see him driving, even though we didn't really see him walk around, I saw when he got into the squad car, he had to use his hand to kind of brace from like kind of tipping over. Or I noticed that his speech was really slurred. And so we actually, I've gone to trial in a case like that where, one of the big things was his speech was slurred. Like, do you know what he normally sounds like? Have you talked to him before? Some people just have slurred speech. That's just how they talk. So a lot of those like objective symptoms that they're identifying are so wishy-washy that it sometimes is the case that there's not enough evidence and juries will come back and acquit, despite the fact that the person refused. So that's a real thing that they deal with. Of course, jurors, I will tell you that I've tried all types of trials and murder, gang shootings, rapes. Jurors hate DUIs more than all of
Yeah.
those. They hate DUIs more than all of those. You know what I mean? So you are not going to it is very difficult to get a jury who's going to be sympathetic to the technical arguments in a DUI trial.
Okay, you get pulled over, you have to show your ID, you have to show your registration, insurance. What about beyond that? If they want to search the car, they want you to come out. Do you have to give consent to search your car? Do you have to come out of the car if they ask you to?
You never have to give consent for anything, and you should not give consent for anything. Oftentimes, police officers will try to get consent in every situation so that they don't have to worry about whether their reason for searching your car is legally sufficient, because the consent overcomes all of that. Oftentimes, also, the way they ask for consent is like, hey, I'm just going to take a look in your car. Like, it's not a big deal. That's all right. And it feels weird. It's like, are you asking for my consent, or are you telling me that's what you're going to do and you're just letting me know? You know what I mean? So I've
Right.
actually litigated in suppression motions, a motion where I say that an officer violated my client's Fourth Amendment right and searched their car. I've litigated the issue of like, was that consent or was that person just submitting to authority? And so the
Right.
language matters, right? But going back to what you said, yeah, you never give consent. There's no reason to give them consent. If they think they have enough to get in your car and search it, then they'll do it. Okay. And if it's wrong and a case comes about, we can file a motion to suppress. For officers, what I tend to see the most, especially before the laws changed, was it's LA. A lot of people's car smells of some faint smell of marijuana. It just, regardless of whether they smoked weed in the
Right.
car or their clothes smell like weed because they were smoking weed before or whatever, or maybe they went to a dispensary, got the weed, put it in under the passenger side seat, and it smells like weed in the car. They oftentimes use that to
Even though it's legal to have weed, it's because it's not legal to be under the influence of weed. That's why they can do that.
the way they work around it is they say, I think it smells like they have over 28 grams of marijuana, which it is illegal to possess that much. And so they say based on the smell, or they'll say, does it smell like weed? It smells like burnt weed, which means that it smells like someone was smoking weed in this car, which means I'm not doing an investigation to find weed, which is legal. I'm doing an investigation to see if someone was smoking in this car because this is now a DUI investigation. And so they
So if
use
the
that.
driver was smoking, for example, yeah.
Exactly. So they use that to try and weasel their way in to be able to search the car. Another thing that they'll do is they'll say, "Oh, you're driving without a license." Okay. They think you've got some other stuff in the car. They'll say, okay, you know what? We're impounding your vehicle and we're just going to do a quick impound search real quick. And they'll go and they'll look through everything and they'll find like a gun. We challenge those a lot too, because first of all, the penal code is very clear. You don't impound a vehicle unless you need to. If you can leave it with the friend who can drive, or if you can safely park it, that's what you have to do. And that's that's from LAPD procedures and manual. And so oftentimes when an officer tries to pretend they're doing an inventory search so that they can get in the car, we can challenge that, and we have. Because they're not, and also when they're doing an inventory search, you're supposed to like have a special form and you're supposed to fill out everything that's in the car. And then you look at the body worn video and it's just them rummaging through the car looking for some kind of paraphernalia or contraband. We can challenge cases on, and we have challenged cases on that end. But you should never consent. And if they have the evidence, if they feel like they have enough to get in and search your car, they're going to do it. And let the lawyer deal with it on the back end.
Would you have a pushback if I said, "Omid, you know what? I'm not really hiding anything. I don't smoke weed. I didn't drink anything. Why should I tell them that I don't give consent?"
Yeah, because you don't know everything that's in your car. I mean, I've got a 5-year-old and a 2-year-old, and my wife sometimes drives my car. I don't know if she left something in there. I don't know if she left prescription medication in there that I could get charged with because it's not, I don't have a prescription for it. Now, I doubt my 2-year-old is bringing, any contraband into the car, but, some people have older kids. You don't know. You don't know. And it'll get blamed on you. You were the driver. Also, I think that there's, unfortunately, in this society, especially in Los Angeles, there are certain people that get targeted for these types of searches, and it behooves us to know our rights and to know what the police are allowed to do so we can create boundaries and limitations so officers know that they can't just bully people and railroad people. When I do a suppression motion, I make sure in front of every judge, I say, look, they may have found a gun and you don't like guns. But this motion isn't about whether we like guns. It's about whether this officer is allowed to do this to any Joe Schmo that's walking around the street or that's driving their car. Because for the 2 gun cases that they get in a week, they're also stopping 10 other people that they don't find anything with, but they're bullying those people. They're harassing those people. Those people's days are ruined. They're delayed. And I'm telling the judge, you have a power to stop this by sending a clear message to that police officer that what they're doing is illegal.
So once you give the consent, basically whatever they find, it's going to make it very difficult for your lawyer to make any sort of argument about that, or at least it limits it. But if you don't give consent, it gives the attorney an opportunity to go in front of a judge and bring up reasons why, even though they found certain things, that they didn't have the right to search to begin with, and to basically keep that evidence out. Is that what that suppression is?
Yeah.
Okay.
Do you mind if I give like a
Yeah.
in the news example of this? Luigi Mangione. Are you familiar with who that is?
Right.
The
Is the guy that
guy,
shot the healthcare guy, the CEO or something like that?
United Health CEO. He basically an assassination. The allegation is that he scribbled on the bullets some creed about like denying and delaying healthcare, and he shot the guy point blank. Right. And then he left New York and he was found in Philadelphia. He was in like, I don't remember what kind of, I think it was a McDonald's, but something
I think it
like
was
a
at
McDonald's.
McDonald's, yeah.
Was it a McDonald's? Yeah. And so someone called the police and was like, hey, I'm not sure, but I think he's in McDonald's. So the police came and they essentially, without probable cause, without reasonable suspicion, they said, hey, I'm going to stop you. I'm going to ask you for ID, even though he didn't have to show them the ID because they didn't have enough at that point to corroborate this identification. And then they said, I'm going to search his backpack because I think he has a bomb in his backpack. And they had no reason to think that. And so they went in his backpack and they found the murder weapon. Now the attorneys in that case are arguing that the police made up the reason for searching the backpack. They didn't have reason to detain him. Just saying someone looks like someone isn't enough. And so it's possible that a judge could find that the detention was illegal and that the search of the backpack was illegal. And what does that mean? That means the prosecution loses the murder weapon. They can now
Wow.
no longer link this weapon that it's not just a gun, right? It's a gun with bullets that were scribbled with specific healthcare related things, right? Like, so it's a huge piece of evidence that they could lose because the police did not do their jobs right. Now, I don't know what will ultimately happen, but this is a huge case, right? And so it's really remarkable to see that this works. benefits the police and society too, for the police to do things correctly, because the last thing you want on a prosecution for society is that the evidence disappears because the cops didn't do their jobs right. You know what I mean?
Right. Right. Let's say you are now arrested. Okay. So you've been pulled over, whether or not there was consent or whatever happened, happened. That'll be litigated later by the lawyers. But now you're placed in handcuffs. What happens next? So you're put in the back of a police car. Can you walk us through the next 24 hours of what that experience is like?
Yeah. So, you get in the back of the police car, police get, they start driving you to the station where they're going to book you. Okay. At this point, they feel like they have enough evidence to arrest you, and they'll start driving you over there. And of course, got to be careful not to say anything. You might be compelled to want to explain your side of the story, or to just talk to the officers because they're going to be friendly with you. But all of that is being recorded. There's a camera inside of the police vehicle, and it's recording everything. They'll take you to the station. They'll basically fingerprint you. They'll take your booking photo, and depending on the crime, they'll put you in jail, or they'll cite you out. They cite you out. They'll write you a ticket after they book you and say, come to this court in 2 months. If they feel like the crime is of a certain nature that requires you to stay in jail, then they'll put you in jail, and you will stay in that jail. And within 24 to 48 hours, court day hours, you will come before a judge, and there will be a criminal case filed. They may not file a criminal case. The police they write the police report, and they present it to the prosecution while you're in jail. And the prosecution decides, okay, there's enough evidence here, and this is a crime is of a type that I want to prosecute. So they'll either file the case, or they'll say, there's not enough evidence, or I really don't want to prosecute this type of crime. You've seen that in like a previous DA administration where they weren't prosecuting certain low-level drug crimes at all.
Mhm.
And so, yeah, then when you show up to court, you're going to get appointed a public defender, or you've hired an attorney. Sometimes, what people will want to do, if they can afford it, is they might want to bail out, right? If it's a 3-day weekend, let's say this past weekend was the 3-day weekend, right? Martin Luther King Day was on Monday. So if you get picked up on a Friday, you might not be coming to court on Tuesday till Tuesday or Wednesday. That's a lot of time to spend in jail, right? So you can always bail out. And that's when you have to get in contact with the bail bondsman. I don't know if you want me to talk about bail, but a lot of people take that option because no one wants to spend all this time in jail, especially for more minor crimes that they're going to get released anyway on.
I do want to get into that. I want to back up real quick to once you get booked, let's say when you're being held, are you in a cell with other people, or are you by yourself? Are you getting put in a jail cell with someone that's been arrested for murder, or like what is that like?
You're initially booked at the station, and they have holding tanks at the station. Who is in that holding tank depends on who's been arrested that night or that day. Certain inmates, I'm now calling them inmates because that's how they're classified. I don't mean to dehumanize them, but certain inmates have certain classification, which requires that they're kept away from other individuals. Absent those type of classifications, you potentially, yes, could be in jail cell with with someone who just is accused of murder. And then, of course, if you're going to stay in jail until court, then they're going to take you to the county jail. So now you were started at the holding tank in the police station, and now they're transporting you to the county jail. In LA County, there's a county jail in the Castaic. There's two located right across the street from each other in downtown, Men's Central Jail and Twin Towers. And there's a female county jail in Linwood. So there's jails all over. Depending on your crime and the allegations and what court you might go to, you'll go to a different one. But essentially, you will be in that jail with every single type of person. Doesn't matter what crime they committed. Doesn't matter whether they're coming down from drugs, whether they're mentally ill, whether they're violent, whether they're non-violent. There's certain carved out exceptions, but yeah, you're in with the rest of everyone else.
Doesn't that seem a little crazy? Like you could be pulled over. You could be a school teacher that got pulled over on suspicion. You might not even be guilty. It's suspicion of DUI. And now you're with some gang member who stabbed somebody. Like,
Yeah,
kind of
yeah,
crazy.
it is really crazy,
Wow.
and that's when you see a lot of these people try to put up their homes, put up their cars, tap family to get bail paid so they can bail out. A lot of people, they don't want to spend even just 2 days in jail. You know,
Well, at what point do you get that? You always see I get my phone call. Is it really only one phone call? And at what point in this whole process do you get that phone call?
so you should get one at the station, and depending on timing of everything, you could. But then at the county jail, you also have access to a phone that you can use. And so lots of inmates will use it if it's available or free, and you can sometimes make multiple calls a day. It's not like it's like sequestered in a secret place. You have to have money on your books to be able to make calls unless it's a collect call. And so that's another way that inmates will make calls. They'll make collect calls, and a lot of attorneys' offices, including my own, they'll accept collect calls, which means that I'll take on the burden of the price so that they can have their phone call for free.
Right.
Yeah.
Assuming, part of that might be to contact a family member to get bailed out because you don't want to be there. What is this bail process like? Can anybody get bailed out? And do you know right away, like how much money you need to put down? What is that process like?
Yeah. So, you need a bail bondsman. All right. So let's just say every single crime has a basic bail amount. Misdemeanors can be around anywhere from like 5 to 10 to 25 to $30,000. If you have probation violations, if there's other allegations, that can increase the amount. And there's a bail schedule that's set based on the arresting charge. And then felonies can be upwards. I mean, my murder client was a $3 million bail. And the idea is this: given an infinite amount of money, if you had an infinite amount of money, you could say, okay, my bail is $30,000. Give the court $30,000 hold. And in exchange for that $30,000, they will say, okay, you can be released. And as long as you make it to all your court dates, you'll get that $30,000 back. Okay. Now, not a lot of people are walking around with $30,000, right? Well, that's where bail bondsman comes in. A bail bondsman essentially is a company that says, hey, I have that $30,000. Why don't you pay me a certain amount of money? I'll put up that $30,000. And as long as you go to all your court dates and everything goes okay, I'll get that $30,000 back, but you don't get the money back that you paid me. And so the question is, cool, that's a service that's worth it for a lot of people. How much is that amount? Well, commonly you'll see like 10% is what you'd expect a bail bondsman to take on a bail. Sometimes it'll be less because bail bondsmen know like, hey, I'm getting that money back probably. This person seems like someone who's like cares about this process. They're trying to hire a lawyer. They're not the kind of person that's going to skip town. So it's worth it to me. I'll take 5%. I'll take, 1% of some higher bail, sometimes 50, 100,000. They'll say, I'll just take 1% because I know you're going to be good for it because I made that assessment. Sometimes people say, oh, you can I'll take 1%, but you're putting up your house as collateral, meaning you own a house. I'm going to get ownership in that house if you don't come back to court. And so there's a lot of different ways that bail bondsmen can be creative so that people aren't like basically breaking the bank to bail out. As a public defender, what I dealt with a lot was the reality of how unfair this is. I would see someone with an incredibly violent case, maybe it was like domestic violence where they like used a weapon on their wife, bailed out because they had money. And then I would see someone on a minor drug case in jail because they didn't have money. And I was like, how is this fair? And that's why you've seen a huge push by certain jurisdictions all over the United States to say, hey, we're going to end cash bail and we're just going to make a determination. You're either safe enough for the street or you're not safe enough for the street. Bail bondsmen don't like that because their business disappears overnight. And I'll be frank, the certain attorneys don't like that because you're now putting the decision of whether someone should stay in custody completely up to a judge. And a judge is a human being. And that judge doesn't want to have the weight of what if I release this person and they commit a crime, is it on me? They don't want that. If a judge is skittish or if a judge released someone last week and they went and committed a serious crime, they may now not want to release a number of people. And so now you're dealing with the subjective emotional nature of this person and their experience and not necessarily an objective observation of the crime. So that's a big problem. And there was actually a big Supreme Court case that came down, People v. Humphrey, that said that the judge has to take ability to pay into consideration. So even on really serious cases, if they can't afford a $100,000 or $200,000 bail, then don't set the bail that high. Set it to something they can't afford.
I see.
Yeah, or release it. And that was a huge deal, because it started to even the playing field a little bit, and it required judges to make a different kind of assessment in terms of whether people could be released on bond.
What about these videos we see on TV where someone's being interrogated? Is that after they're arrested, or is that just one way you could end up in jail is you're pulled over, you're arrested, go in jail. Another way is you're suspected of something, you're interrogated, and then you go into jail.
Good question. we discussed that period of time where you're in the holding tank at the station before you go to county jail. The police use that time in certain crimes in order to do their further investigation. And if there's a detective that's kind of like the lead on the case, well, that detective's like, okay, a lot of the elements are met, but this case would be a lot stronger if I had a confession from this guy. Or I think he committed the crime, but we're missing this one element of the crime. And if he gives it to us, we have enough to present this case to the prosecution. So they'll put you in a room, and oftentimes two cops come in there. It can be kind of a good cop, bad cop situation, or they just take on different roles in the interrogation generally. But they put you in there and then they read you your Miranda rights. It's something they have to do. And police officers are very, very good, ones who are experienced at making criminal defendants or people accused of crimes feel very safe and comfortable with them. And they have a lot of quasi coercive tactics to use to lull them into a sense of security so they feel comfortable pretty much confessing a crime. They'll do things like try to pretend like they're not judging them. So they'll be like, hey, listen, I get it. You know, your girl was talking back to you. She made you really upset. And, you shot her. I totally understand. I've kind of felt that way about my wife too. Like, we're not here to judge you. We just want to know what happened, and I think it'll go better for you in court if, you talk to us now. I could recommend to the judge to go easy on you. That last statement is a statement that I had verbatim in a case. And I actually was able to use that statement in suppressing the confession because I said, hey, look, he made a promise of leniency. He can't do that. That's coercive. The law is that if you coerce someone into uh, waiving their Fifth Amendment right, then it's not a real true waiver. And so this is the kind of thing that happens a lot in these rooms. But the smarter officers know how to skirt the line. They know how to say the exact right thing. They know how to play the psychological warfare. One other thing they do is that I've seen this in many of my cases where they'll generate a fake DNA printout and they'll say,
Mm.
hey, just so you know, like they'll slide it across the table. Lab receipts came back. Your DNA was on the weapon, right? And of course, if you committed the crime, you're like, oh crap, they have me. I might as well talk. If you didn't commit the crime, but maybe you're mentally unwell, maybe you're not really in your right state of mind, could be a lot of things going on. You may actually end up confessing to a crime you didn't commit because you're thinking, maybe I'm wrong. They have DNA tests. Who am I to say I know more than the DNA test? You know what I mean? And this
And
is,
what's the boundary between, like, lying and coercing? Because that almost seems like coercing too. Are they allowed to lie, and at what point is it not lying and it's coercing?
yeah, that's a good question. The boundary is one that's not drawn with a black letter line. It's always like on a case by case basis. Judges will always look at all the circumstances to determine whether something was coercive in nature by the police. They'll look at the age of the person's. What a police officer does to a 19-year-old will be viewed differently as to what a police officer does to a 35-year-old, even if it's the exact same thing. But their Supreme Court has ruled, and many cases have agreed since then, that a police officer can lie to you in the interrogation, and that's not improper. So they can lie. Yeah. And then where it becomes coercive is, are they making promises? Are they making threats? I think you sent me a video where the police officers had their family dog in the room with them and they said, hey, we're going to euthanize your dog if like you don't confess to us, like it's going to benefit your dog. And so of course, now this person's like, I could get my dog killed. This is like my family. That was deemed to be coercive in that case. It's one of those things, kind of like really case by case basis, but we always want to argue that what they're doing is completely coercive.
What is entrapment? And what are cops allowed to do and not to do?
Look, entrapment is one of the most commonly misunderstood and commonly asked about forms of defense that I get asked about by my clients. So basically, entrapment involves coercing a person to commit a crime that they would not have otherwise committed through actions of law enforcement. Case law has been very clear that there are a lot of things that we would imagine as entrapment are not entrapment. So, for example, a police officer going to a sex worker on the street and saying, hey, do you want to come to my house? I'll pay you this much for this sex act. That's not entrapment. Putting a bait bike out in public to see if someone steals it. Just putting it out there without a lock, that they don't deem that entrapment. The example of the bandit taxi cab that you just discussed, none of these are deemed entrapment. And so it's one of those things that I haven't seen it once in my entire criminal defense career, because it just doesn't, it's just such a hard standard, such
Oh,
a
I
hard
see.
standard to prove. Yeah, yeah, yeah,
I don't, and there's that thing you see in the movies all the times, like, "Are you a cop? You have to tell me if you're a cop."
yeah.
I'm assuming that they don't have to tell you that. I mean, they could lie to you and say, "I'm not a cop."
No, no,
That's not
they can
entrapment.
literally, yeah, that is not entrapment, and they can lie to you. Absolutely, absolutely. It would be fun though.
Got it.
It'd be cool if that was like a, secret hack.
Right. Okay, so you have bail, you don't have bail. Either way, you're now being charged with something. What is that process of looking for a lawyer? You know, you're somebody who's never been charged with a crime, and now you're looking for a lawyer. I mean, first of all, how do you even find a lawyer? You know, how do people
Yeah,
find them?
absolutely. Just so typically, if someone is looking for a private lawyer, they're going to take a different path than if they're just going to see what happens with the public defender. If it's the public defender, then you're going to wait till you go to court. You have to wait till the case gets filed, and you have to wait till you go to court, and then the court appoints the public defender. That's typically the first time you meet them.
Not everybody can get a public defender. You have to be deemed, financially not able to hire a private lawyer. Is
Yeah,
that
you have to
the
qualify.
case?
Yeah, you have
Oh,
to
how do you
qualify.
qualify? What does that involve?
So it used to be, back when I started practicing, it used to be that we would have to give them like a financial kind of questionnaire before the court would appoint them. And we would ask these like super personal finance questions. You would always see these people like really struggling to be like, I want to justify getting a public defender because I really can't afford an attorney, but I can still pay rent. I can still get
Mm,
groceries. These questions are so invasive. The public defender's office and the court system has since done away with that stuff. And it's basically now just a presumption that you don't qualify. Unless, of course, people notice things about you that makes it seem like that you wouldn't qualify. I think maybe I misspoke. What I meant is that it's a presumption that you do qualify for the public defender's
mm.
office, and that can be rebutted if either a judge or the public defender's office or the prosecution is like, hey, this guy showed up in a Maserati. This guy showed up in a BMW. This guy owns a home. Why is this person qualifying for the public defender's office? And you can make a motion to disqualify them. And then that's one way you can get the public defender off the case. And then they have to hire their own lawyer. But a lot of people, they may get arrested and then cited out and they have court in 2 months. And they don't want to wait 2 months to talk to a lawyer because your public defender is not going to talk to you until they are with you at the arraignment and they get appointed. And so there's a lot of stuff that you can do beforehand to even avoid a filing. Oftentimes, an attorney can intervene, a private attorney can intervene. They can talk to the prosecution, they can talk to the detective, and they may be able to avoid a filing altogether. And that's huge, right? Because once the criminal justice machine starts moving, it's really hard to stop it. The momentum is such that you really have to show a lot and do a lot to get that case either dismissed or to go to trial and win that trial. I mean, I can tell you, like, the process of starting case at arraignment and going to the end of trial is so draining financially, emotionally, that by the end of it, my innocent clients are still really angry after they win their trial because they're like, I lost so much of my life to this.
Mm.
And so, intervening beforehand is important. So finding a private attorney, I think a lot of people do want to do that. And how they find it depends. Sometimes some people maybe know a lawyer, or maybe they know someone who knows a lawyer, so they'll ask. Other times people are just going on Google and they're searching. And the lawyers that they get on Google, some of them are really good. Some of them just happen to have a lot of a marketing budget,
Right.
and are able to get, high up in the Google search. And I know you probably know about that really well because no one spends more money on advertising than personal injury lawyers, right? Like
Right.
it's a huge industry. And so you don't know if you're getting a good attorney just by seeing their reviews or just by, seeing how they show up on Google. And one of the things that I was always frustrated with as a public defender, and I'm now experiencing now too, is that every attorney is willing to take your money whether they are competent to handle your case, unfortunately. And when someone takes your case and they're not competent to handle your case, it's really difficult as a public defender when I was sitting on the sidelines to watch certain private attorneys kind of bumble through cases and do poorly for a client who really had a defensible case because that person just, was like, hey, I'll take your money. I would say that anyone who's trying to hire an attorney, ask that attorney, first of all, call numerous attorneys. If you don't have someone referring you a case that you trust or referring you an attorney that you trust, and you're just blindly kind of calling like people on Google, talk to numerous attorneys. Get a sense for, am I talking to the actual attorney or am I talking to a salesperson or like a
Mhm.
front desk receptionist? If I'm talking to the attorney, are they listening to me? Are they kind of listening to what my goals are, or are they just talking at me? Are they bragging about about their accolades, or are they actually thinking critically about what I need and what needs to happen in my case? Have they handled cases like this case? Have they gone to trial with cases on this case? Do they go to trial? I've seen attorneys that are afraid of going to trial, and certain jurisdictions, you have to sometimes set the case for trial before you get the prosecution to make a deal. And so, how are you going to do a good job on that case if you're not willing to go to trial? I think those are the important questions. And I think people need to be really critical with who they hire because you're spending a lot of money, and this is your life. So make sure you make the right decision.
You could tell me it's a myth or not that there is some benefit to hiring someone, like, for example, if you're being charged with a crime in LA County, there's some sort of benefit to hiring someone who is either a PD or former prosecutor in LA County because they feel somehow they know somebody who knows somebody. How much of that is a myth and how much of that is practical?
That's a really good question. I'll give you an example. So the last court that I practiced in as a PD, I handle private cases there now. And I have an advantage in that I know all the judges, I know all the prosecutors. And it's not necessarily like they want to do me favors, but I know how to navigate, criminal defense is like chess. It's about where you put your pieces and how you navigate the system. It's very strategic. And so I know how to navigate that court really well and figure out what the best direction is. Should I set it for trial? Will setting it for trial cause problems for us? If I put pressure on this DA, are they going to give me a better deal, or are they going to be angry and actually work
It's a
harder on
lot
the
of
case?
intel you basically have. You have the intel that you can use to make better decisions.
Exactly. But as a private attorney, what I'm learning is there are private attorneys that are able to get all this intel all over the county, all over other counties, and they practice all over these places. Well, if I go to a court that I don't know the judge and I don't know the prosecutor, the first thing is I do is I walk to the PD. If it's in another county, I walk to the PD and I say, hey, do you mind if I pick your brain a little bit? And I get incredible information out. And you need an attorney, I think, that is willing to do that, that doesn't think they know everything or that they're going to carry the day with their swagger, that really digs in and says, okay, let me get a lay of the land to see how to navigate this. So do I think it's beneficial for a PD or for an attorney to know a court? Yes. But I think it's more beneficial for someone to seek out that information at all times because ultimately judges change, prosecutors change. So you always have to be asking questions and figuring out those things.
Okay, so now let's say you have an attorney and you've just been retained. What does that next step look like?
So I'm being retained, what the first thing I'm doing is, okay, have they filed a case yet? And if there's DUI involved, I'm immediately sending a notice to the DMV that I've been retained and that I want to request a DMV hearing because otherwise your license is going to get suspended within 10 days of your arrest. And so that you got to jump on that quickly. So anyone who's getting arrested with the DUI needs to act immediately in hiring an attorney. Public defenders do not do DMV hearings. They're not even they're not appointed for that or at that part of the process. So you need a private attorney. If it's not a DMV related case, I'm seeing if this is a case potentially that, hearing my client's side of the story may be helpful for the prosecution in deciding if they're going to charge. So I may get an investigator, talk to certain witnesses, get mitigation, and I might put together a packet that I give to the prosecution to convince them not to file charges or maybe to file less serious charges on the case. And that has been something that can be very successful depending on where and what the case is. And then that attorney should be, I typically will work with that person and find out the whole story, make sure I preserve any evidence that's preservable. Oftentimes, surveillance videos get recorded over within 48 hours, sometimes 2 weeks, sometimes a month. So those are the type of things that you need to jump on immediately, and then, you wait until your arraignment hearing or your first court hearing and you show up to court and then that process starts.
How much of your ability to help is limited or enhanced by the amount of money that a defendant may have to put into a defense, whether that's helping you hire investigators or experts or things like that?
Yeah, no, that's a great question. So one thing that we do a lot is mental health diversions. There's a law in California that says if someone is suffering from a mental illness and they committed a crime and there's a connection to that crime and their mental illness, and we can provide treatment for them, they may be eligible for what's called mental health diversion, which means that instead of suffering a conviction, the case gets put over. If the judge agrees, the case gets put over for 1-2 years. And if they do everything they're supposed to do, the case gets dismissed before any conviction happens. And the idea behind that is to say, hey, mental illness is, we see mental illness cohabitating with people who are justice involved quite often. And so if we can treat these people, we can avoid the collateral consequences that come with conviction and jail sentences and whatnot. And so I bring all that up to answer your question of, you need to get a psychologist or a psychiatrist to do an evaluation, to do a mental health diversion case. And oftentimes those things cost a lot of money. They can cost $1,000. So, if you are privately retaining me, typically the arrangement is that we decide together if you're willing to pay the money for that. And a lot of people can say, hey, I kind of just spent all my money on you. I don't have that money. So oftentimes I may appeal to the court and say, hey, Your Honor, he no longer has the money. I write a motion. I say the financial situation is really bad now. He can't afford this, and it's a necessary and proper part of his defense. We need to get this expert. And sometimes the judges will pay for those experts on the county dime if I can
Mm.
make a proper showing. Yeah.
And
It
this is
doesn't happen.
because this is a criminal case. I mean, you don't see this happening in civil, but anytime I guess it's involving your freedom, it kicks in your constitutional rights and things like that, which is why you get the government footing the bill for some of this stuff. And so is it fair to say there is some truth to this idea that if you're rich, you have kind of an unfair advantage in the criminal justice system?
Well, man, that's really, really tough. I think the answer is yes. I think that you do have an unfair advantage. I think that, think about the OJ trial. He had multiple lawyers and they were all handling different parts of the case. And they were all like experts in their own right, in their own individual parts of the case. They all brought like something to the team that made that like a dream team. A regular Joe Schmo is not going to be able to pay for numerous high powered lawyers. So there's something very real to saying if you have the money for that, there's an advantage to that. I would say that also being able to pay for a lot of experts that maybe a judge would not agree to appoint can definitely be advantageous as well. With that said, I think I think a good attorney can know how to justify various experts in a case. And when you write a motion to get those experts appointed, if you write it in such a way as to say, hey, if you don't do this, they're not going to get a proper defense. Well, the judge is hamstrung because the last thing the judge wants is when an appellate reviewing court looks at it, says, hey, this person wasn't able to even put on a proper defense because you denied this expert that's necessary for their defense. Then the case gets overturned. So I do think rich people have a huge advantage in the system, but I think that good attorneys can cut that advantage significantly. I really do believe that.
That's a good point. Very interesting. And was there ever a time in a case where you felt like you could have been advantaged by an expert, but the judge would not pay for it?
Yeah. Yeah. I mean, one of the things that judges oftentimes do is they'll say, hey, I see that you want to appoint this psychologist because you think your client needs this evaluation. And this psychologist is asking for this X amount of money. I think that's too much. I'm only going to give them $500. And of course, I either go back to them and they say, I can't do it for 500, or they'll say, okay, that means I'll only spend an hour on it and I'll do the report really quickly. And then of course, what happens is 3-4 months later, you go and you have the hearing and the judge is like, I'm not getting anything out of this report. This report barely has anything. This isn't helpful at all. And so they don't even remember that they denied the funds for a proper report. So yeah, absolutely. Absolutely. Judges, every time there's a meeting, all these judges have a meeting and the head judge says, we're spending too much on these experts. You need to cut it back. Well, then all the judges go back to court and they start slashing the prices, slashing the rates. And then the experts aren't able to do the job that they need to do. So yeah, absolutely.
Right. And then so now you're on the case, you have maybe some experts or some investigators or some sort of case building, defense building going on. And one of the things you see a lot in movies and TV shows still is this battle between kind of the defense lawyer and the prosecution. There's this kind of general sense that the prosecution doesn't always share everything that it should share, or that it doesn't share it in a timely manner. See that whether it's I think it happened in that shooting case, the Rust case. What was it? With
Yeah.
Alec Baldwin.
Hmm.
There were some bullets
Testing of
that I
the firearm.
guess,
Yeah.
yeah, there were some bullets that were found later, and then it's a question of what impact does that have on the defense, or it might be a witness that's not identified till last minute. How much of that is true in your experience where like things aren't being shared, and how much of that do you attribute to like the prosecutor trying to get an unfair advantage versus just the bureaucratic red tape and general incompetence that might happen at any organization?
Yeah. Just like in anything, there's a lot of bad apples, and you have it in the prosecutorial office as well. So it's going to be dependent, on a person to person basis. Now, the DA's office it's a small world. It's not like a personal injury where there's hundreds of different like personal injury lawyers and defense lawyers, and you may not see the same person very often. In in criminal defense, we all see each other. We all have reputations. So there are some prosecutors that have a reputation for hiding the ball. And defense attorneys talk, judges talk, and we know who those people are. I have done really aggressive discovery practices with certain prosecutors that I know are shady. And that means I put everything in writing. That means I make formal discovery requests that I file with the court. That means I ask the court to make that attorney assert that they've turned over everything. And by doing that, cover my butt, because what happens is when I set the case for trial and they're like, oh, yeah, we have this too. They can't hide behind, well, they never asked for it, right? Because I've made the paper trail. So you have prosecutors like that. You have prosecutors that look at their job less as like truth finders and more as like adversarial, like I just want to win, attorneys, If you are an attorney that just wants to win at all costs, maybe go into private practice, whether it's criminal or civil, right? But you should not be a prosecutor, because a prosecutor is bound by different ethical boundaries. They have to they it is in the Supreme Court that a criminal defense attorney can be somewhat tricky without violating ethics, can be somewhat tricky or hide the ball on certain things in order to adequately represent their client. The DAs, prosecutors, they don't have that same. It's not the same for them. They have to be above board on everything. And that includes handing over all discovery. So I've had numerous times discovery show up in the middle of trial, or discovery that was never handed over come up. And I've made motions for the court to levy huge sanctions, not monetary, but things up until dismissal of the case or jury instruction saying that this DA hid the ball. And judges are afraid to do it because they are afraid to cast aspersions on attorneys. You know what I mean? They don't want to hurt anyone's reputation. But certain judges that have the cojones will do it. And that's what I've experienced. So you always have to be vigilant.
These people that have that reputation for hiding the ball, how do they still exist in the system? Is there no punishment for them? Is there no way to get them out of the system?
If you work in a courthouse that is extremely prosecution friendly, then you're not going to have them held accountable. And if if no one's reporting them to the bar, or no one's doing the work to hold them accountable, then they're going to get away with it. And that's what happens. It's only when you're in more defense friendly courthouses that the judges say, wait a minute, this is completely inappropriate. And to be completely frank, it's not even necessarily like judges that were former public defenders. A lot of judges that were former prosecutors end up being very, very tough on prosecutors because they know what the job takes and what the obligations are. And when someone's doing it the wrong way, they're extra annoyed by it. You know what I mean? Um, and the truth is, when the prosecutors are shady, that's how criminal convictions can get overturned. So someone who could
Mhm.
otherwise be very guilty of a crime, a very serious crime, may have their conviction overturned because of shady prosecutors. Again, that's not good for society. That's not good for anyone, right? Good for the defendant, but not anyone else. So judges also are on top of them, if not for it's the right thing to do, but because they don't want to create a record that's going to cause this case to get overturned.
What about, okay, so now you get all the evidence from the prosecutors. I think one of the difference between civil and criminal is you don't get to depose anybody, right?
No, you don't. So in a felony, you have a right to a preliminary hearing. And a preliminary hearing is like, I would say it's like one of the closest thing to a deposition, right? Because the preliminary hearing is the prosecutor has to show that there's a probable cause to keep you in jail or to keep the charges against you. And all they have to show is probable cause for each element of the crime. Now, this was with all the crimes that happened in California. This was such a burdensome lift for prosecutors because you had thousands of crimes being filed, and then you're dragging the witnesses in literally 1 to 2 weeks after they happen. A lot of people can't come. A lot of police officers are busy. Maybe they're handling something else. And so cases were getting dismissed left and right. And so essentially there was something called Proposition 115, and that made it so prosecutors could practically put on certain police officers to just testify to hearsay as to what the witnesses told them. So in theory, the preliminary hearing is an opportunity to cross-examine witnesses in a case. But in practice, what ends up happening oftentimes is that it's the police officer that spoke to all the witnesses up there on the stand just reading their police report.
Wow.
The rules of evidence still apply. Hearsay is allowed. One layer of hearsay is allowed. Sometimes on more serious crimes, like certain sex crimes or crimes that involve the credibility, a serious crime where the credibility of the alleged victim is at stake, prosecutors want the person to come because they want to see the value of the case too. They want to see if this person is telling the truth, because felony cases can drag on for years before going to trial. And so you're going to have someone in jail for 2 years before they go to trial. You want to make sure that at least this is a credible allegation.
Right.
But on non-felony cases or in cases where they just put the police officer to read the police report, the closest thing we get to a deposition is by having appointing an investigator to go and talk to the witnesses and getting that investigator's impression of the witness. Problem is, the witness can say, I don't want to talk. The investigator has to announce themselves as a defense investigator. And if the person says, I don't want to talk, they have to back off. They can't be pushy. They can't reassert themselves or anything like that. So oftentimes you don't know the value of a case until you go to trial. Your
Wow.
client could be telling you, I didn't do it, but the prosecutor is just looking at words on a police report from like 9 months ago. You know what I mean?
Right.
And so that's one of the biggest problems with, I think, our justice system, is that really bad cases make it way too far in the system before they're vetted. And their vetting happens at a very high stakes time, right? You're bringing in 14 jurors 12 jurors and 2 alternates to listen to the case. You're stopping all things. Some people are taking a work off. And so you have to get to that point before you realize the value of a case. So prosecutors should be bringing witnesses to court early on in the case and talking to them themselves to evaluate the case. But oftentimes they're too busy or don't feel like doing it.
And then you probably have a certain number of people that might win a trial, but because of that disparity in information or access, they might be taking plea deals that they may not have taken if they had access to that, right?
Absolutely. If that person's in jail and the offer is you'll get out of jail if you admit to this crime, and if you want to go to trial, you have to wait a month in jail. What are you going to do? You're losing you might lose your job. If you lose your job, you lose your home. You lose your home, you're homeless. What are you going to do? You're going to take the deal, go home, take the conviction, even though you're innocent, so you can not lose your home. And it happens all too often. It's really quite sad.
I didn't even think about that. Yeah, I mean, your job, your bills, all that stuff, I guess, is still waiting on. I didn't even think about that.
Yeah.
That's
Yeah.
crazy.
I mean, you think, we have, you work for yourself. I work for myself now. But, if you have a boss, how long is your boss going to be okay with you like sitting in jail before he's like, I need to replace you?
Or
Or
even
if you
for you and I, if we're in jail, our clients aren't waiting for us. You know what I mean? It might even be worse for us. We're done.
Yeah, no, you're absolutely right. You're absolutely right. Yeah. So and prosecutors know that. And that's why they'll offer, the shadiest thing I see prosecutors do is that they'll argue that the person shouldn't be released pending trial, but then make an offer of them being released if they take the deal.
Right.
So it's like, on the one hand, they're trying to say you're too dangerous to be on the streets. But on the other hand, they're saying, we'll put you on the streets if you admit guilt.
It's for leverage,
Right?
yeah, and I saw that working at a criminal defense firm where they overcharge people in order to try to get them to get a plea deal. A lot of the stuff you're talking about now, try to keep them locked in. It's all things to kind of gain leverage to get a plea out of you.
Yeah.
Plea that's more favorable for them and less favorable for you.
Yeah.
And so I remember that being one of the things is like, uh, when my boss was being interviewed and they're like, well, how do you feel representing guilty people? I mean, there's multiple answers to that. But one of them was that just because you're guilty of A doesn't mean you're guilty of B. And a lot of times in these criminal cases, you were being charged with things that the charge didn't match the crime a lot of times.
Yeah. Yeah.
And on that front, how comfortable can someone feel telling the complete truth to their defense lawyer. If you have done something, are you basically battling to sell your position to your defense lawyer? Or are you afraid that if you tell them the truth, he's either going to go tell the prosecution? Like, there's a lot of people don't have a lot of information regarding how that whole thing works.
Yeah. Yeah. No, it's really hard. People think that if they admit that they're guilty to their defense lawyer, that the defense lawyer will like not try as hard, or that they will just like kind of like sell them out to the court, to the prosecution. Sometimes they're just kind of too embarrassed, and they're embarrassed to lose face in front of their defense attorney or even to their family. I've been doing this for 14 years now, and I'll tell you, I can now tell when someone's being untruthful with me. I can parse it out, but I feel like that's a failure of me if someone is being not truthful with me, because at the end of the day, it's my job to make sure that they know that A, we have a attorney-client privilege and a confidentiality, but B, that they trust me and they know that I'm not going to judge them because of what happened. That I'm not here to pass judgment. I'm here to fight for them and to tell their story. You can be as guilty as sin, but there's always a story, right? There's always a reason that you showed up there. Representing juveniles, I realized that like no one is born to commit crime. The trauma, the mental illness, developmental delays, the life experiences, all these things contribute to what ends up putting a lot of these kids and then later adults in the criminal justice system. And it's most of the time it's things outside of their control that are controlling them. And I'm not to say that people aren't accountable for what they do, but that there's always a story as to why someone is deserving of compassion. And I think I always look at my job as being able to tell that story for someone. I always think that's really important. So I hope that when I work with a client, I hope that I can always elicit that trust in them so that they are being truthful with me. Because the first thing I'll tell them is like, you lying to me is going to make it harder for me to do my job. Because if I'm going on wild goose chases, I'm not spending the work on the other type of stuff that might be more beneficial to your case.
Is that covered by attorney-client saying, hey, Omid, I did kill that person? Is that attorney-client?
Absolutely. It is what attorney-client privilege was designed for, right? The only thing that that creates issues is if they make an actionable threat with a specific threat against someone, and we believe them that they're going to actually commit the threat. And then even in that case, it's permissive as to whether we, report that. It's not required. Yes, if they tell me, hey, not only did I kill this person, but I have 3 other bodies that I'm worried are going to be associated with this gun that they have. It's not my job to say, man, that makes me really uncomfortable. It's my job to protect them. And if I don't, then I'm not doing my job, and then I shouldn't be a criminal defense
And you
attorney.
can't share that with anybody. That's between you guys.
Yeah,
Yeah.
absolutely. Absolutely. Yeah. And it's happened. I've had that conversation multiple times with people. And it's funny because working with juveniles tend to tell the truth all the time. And that's one of the craziest things about them is that they're like, whatever, I'll just tell the truth. I can't foresee consequences as well as adults. And so they tell the truth, but it also helps the attorney-client relationship because I now know where I'm working with.
Right. And
Yeah.
does that change the strategy at all? Like the guy says, or the girl, I did this, but I still want to fight it.
It's not what did Denzel Washington say? It's not what you know, it's what you can prove. So what I mean by that is it doesn't matter what they tell me. What matters is the state of the evidence. Okay. So if they tell me that they did it, but I think, hey, the state of the evidence is so weak, we can go to trial, then that's my job and if they want to do it, it's my job to go to trial and try to fight for that, to fight for a not guilty verdict. But of course, if they tell me, hey, I did it and I just want to resolve this, then I'm going to do what they asked me to do, right? I'm going to work towards resolution. Doesn't mean I go and tell the prosecutor, hey, he admitted it. Unless he says, hey, I want you to go tell them that because I think that by taking accountability, I might have a more favorable result. And if I think that's reasonable given the prosecution and all that's, and there's no pitfalls to that, I'll follow the client's wishes. But more often than not, there is pitfalls to that.
Probably the question I assume you may, how can you defend somebody that you know is guilty? I've seen different answers to that. I've seen, well, I'm not defending the person. I'm defending the system. I'm defending the rights. I'm defending the process. What's your mindset on that in terms of what are you defending?
Yeah, well, I think the problem is the word defending, right? Like the word defending has so many meanings. One meaning is it sounds like you're defending the actions, right? It sounds like you are supporting the actions when you say, I'm defending this person. But that's not what criminal defense is. It's not a support of the actions, right? You're not saying like robbing and murdering isn't so bad. That's not what you're doing. What you're doing is you're making sure that person has competent representation in this criminal process. And competent representation means that you are poking holes to the best of your ability in the prosecution's case, and you are investigating whether there are any defenses. And if there, and in addition to that, I look at my role as saying it's not about defending what they did or what the actions are, but it's about telling their story and making sure that the system, the prosecution, the judge treats them like the human being that they are, along with all the circumstances that makes them who they are, as opposed to the police report, who they see in the police report, because you are dealing with a human being. What I spend an inordinate amount of time doing is getting a social history, having a psychologist evaluate my clients, finding out what their mental health situation is, finding out, unpeeling the layers of complex trauma. And I have never encountered a case that I couldn't look at a client and say, this person is not, to some extent, a product of the traumas, the mental illness, everything that they have experienced. And I've done this on some of the most serious cases. And I have been able to, I think, show the humanity of my client, in a way that I think softens prosecutors, softens judges, and ultimately gets us more fair results. It's not about just
Right.
getting everyone off and saying you're innocent or guilty, but it's about, like you said before, making sure that the punishment fits the crime and that we look at rehabilitation and not just punishment. Because if you keep punishing someone, but you're not fixing the problem, well, when they get released, it's going to happen all over again, right?
Right.
At some point, we have to try something different.
As you're trying to decide how to guide your client on what to do in a case, whether to take a plea, go to trial, how much of a difference does it make where your case is? And then what I mean by that is, number one, which judge is in front of, because ultimately a judge might decide the sentencing. And number two, where the jurors come from. And so depending on who your client is and what city or county or courthouse you're in, are those things that you're factoring in? And how would you explain that to like the everyday person, of how maybe the same case, you might advise different things depending on where you're at?
Huge difference. Huge difference. And you hit the nail on the head. The judge makes a big difference. The jury pool makes a big difference. And the prosecution makes a big difference. You are charged with a crime in an affluent neighborhood. The prosecution is going to go harder on you because they're going to be less forgiving. So
So
I'll
like a
give you an
rich,
example.
when you say affluent, you mean like a rich
Yeah.
place?
Yeah. Yeah.
Okay.
Yeah.
Like a
If
Beverly
it's like,
Hills.
what was that? Yeah. Beverly Hills. Exactly. Yeah. Certain status crimes that have to do with being homeless or whatnot, there's a lot of leniency to them in downtown. There's not a lot of leniency to them in places like Long Beach or places like Airport Court, which is on the west side near LAX. I'll give you another example of jury pools. One thing that's really common in gun possession cases is the police see someone that they think has a gun and the person starts running. Okay. And then the police sees them and then sees them pull the gun out of their pocket and throw it either on a roof or in a bush and keep running. And then, of course, they ultimately arrest that person. They go do a search, they find the gun, and they say, okay, this is the gun they threw. Okay. And those types of cases in many jurisdictions, you take that to a jury trial, the client's gonna lose. In Compton, people don't trust police officers. So they say, if you didn't find it on that guy, I don't believe that you didn't plant it. I don't believe that it wasn't another gun that someone put from another time. So I'm not going to believe it. I'm going to acquit that person. And part of being able to do your job is knowing how the jury pools are different in different places, because that's a reality. Certain places do not trust police officers. In Lancaster, which is in LA County, believe it or not, you'll get maybe people that are willing to trust police officers, but they don't trust the government. People find it useful. Defense attorneys find it useful to refer to the prosecution as the government when they're
Mm.
doing their arguments or in trial, because people tend not to trust the government. Every single area is a product of the jury pool that's there, but also the prosecution. The last elected DA, George Gascon, that we had, he saw that as a huge problem. And so he promulgated really uniform prosecutorial standards across the whole county, which pissed off a lot of prosecutors. But his whole thing was, it's not fair that because of where you committed a crime, you're going to be treated differently in this county. Of course, now he he lost, and now a much more hardline prosecutor is in office, and now that disparate judgment is back, and with a vengeance, to be completely honest with you. And so it's really, really not fair. It's really, really not fair, and that's just a reality. Certain judges have perspective, certain judges have biases, and so that's just something we deal with in the system, unfortunately.
A lot of times you've heard judges referred to as like the 13th juror because they can put their finger on a lot more than most people think in terms of like what evidence comes in, what evidence doesn't come in, what sanctions come in. For example, if a prosecutor does do bad faith conduct, what is the result of that, and that could favor your client or to varying degrees. How much of a difference do you think it makes the judge you have when it comes to sentencing? And how does that play into whether you take a plea deal or not? Because obviously the police recommend the charge to the prosecutor. The prosecutor decides to charge and then ultimately has to prove the case. The jury has to decide whether or not they think your client is guilty on a unanimous basis on a criminal case. But then it's not the jury that decides the sentencing, right? It's the judge.
Yeah. Yeah. So the jury decides certain things that dictate the sentencing. So if there's like sentencing enhancements that could add time, or there's circumstances and aggravation or aggravating circumstances. So like, did they have one of them is like, do they have a criminal history? Have they been to prison before? Sometimes juries will decide that as well. And those things do kind of dictate the boundaries that a judge can sentence on. But yes, absolutely. Like when it comes to deciding whether someone's going to get probation or get sent to prison or get sent to jail, it's the judge deciding that. When it comes to whether or not that person on probation is going to, be required to do treatment or not, the judge decides that. So, in federal jurisprudence, there's a lot less leeway for the judge. Prosecutors can really dictate a lot based on what they charge. But at the state level, a judge has a lot of options. And different jurisdictions like Long Beach is known for judges just denying probation and maxing out people on misdemeanors. What does that mean? Denying probation means not even saying I'm going to put you on probation, and just giving you the maximum jail sentence allowable by the crime.
Wow.
That would be unheard of in downtown. But in Long Beach, it's a regular practice. That's just the culture of the judges there. So it's just a reality that the judges exercise a lot of leeway. And some judges are so compassionate, and you make the right arguments to pull at those heartstrings, they'll do the right thing with our clients oftentimes. But it can be very daunting to be in front of a judge that is not, or that has like a chip on their shoulder. Certain judges, like, they have a certain thing about domestic violence. They have certain things about DUIs. And so they just sentence more harshly on those crimes in particular. Certain judges have biases, and there's actually a code section that allows us to disqualify a judge once in a case called 170.6. So if we feel like the judge is not going to be good for us at the beginning of the case, we just drop a 176 motion, and the judge has to, no questions asked, disqualify themselves, and then your case gets sent wherever. But it's a strategy. I told you earlier, it's like, this is like chess. That's one of the moves in our chess game of criminal defense.
I've even heard where you can agree to a plea deal with a prosecutor, but then the judge rejects the plea deal.
Yeah.
Is that real? Does that ever happen to you?
Yeah, and it happens in the most frustrating cases, because you'll have like a really serious crime, and you'll do all this work to show that the case is incredibly weak, and the client maybe doesn't want to go to trial because the risk is so high of felonies. Like, you can do many years in prison if you lose a trial, but maybe you're able to show that the case is really weak and the prosecution may lose at trial. And so they give a sweetheart deal. And then when you go up and you try to take that deal, the judge feels like, wait, this is a really serious case. Why are they getting this sweetheart deal? And then they'll reject the plea deal. And it's frustrating because the judge is not privy to all the stuff that I showed the prosecution, right? That they're not supposed to look at the state of the evidence, yet they're stepping in and intervening, and it's really, really unfortunate. We've had to go to trial on cases like that just because the judge is, refusing. Now, there's things that you can do, right? I often always kind of like will say, like, Your Honor, there's a lot of weaknesses to their case. There's significant problems of proof. They're doing this because they very well would lose a trial, and my client, is not opting for trial. And so you kind of telegraph that stuff to judges, and that kind of makes them go, oh, okay. And that's why it's important to like build trust with judges, so that they know when you say something like that it's real and you're not just like blowing hot air out.
Right.
But Yeah, judges, yeah, they blow up plea deals all the time, especially judges who like to be in control, and so it's always something to avoid. In juvenile practice, the judge says, "I don't care what you worked out, the charges are up to the prosecutor and everything else is my purview, and I make the decision, ultimate decision." So it just
Wow.
depends. Yeah.
Which has always been so interesting to me because I would have thought that a judge would look at a prosecutor and say, well, you know what's going on. You know the strength of your own case. You're the one that has to prove it. So if you've decided to give this plea deal, the adversarial process exists so that we can reach, a resolution that, falls somewhere where it should. It's crazy to me that a judge could just reject that.
Yeah, I mean, your thought process is so high-minded and intelligent and thoughtful. You'd be surprised that you can't ascribe that kind of thought process to many judges. But, judges are always afraid to. Cases end up in the news, right? When a prosecutor gets a sweetheart deal and the judge goes along with it, the judge's name there in the news article that that person went out and killed someone or did something bad afterwards. And so they're always worried about for themselves too, because judges have to campaign, they have elections. And so the last thing they want is to have a case like that on their name, and then there's an election, and then that they lose because that case is associated with them. So there's a fear element, I think, but ultimately I think a lot of judges just don't necessarily, I think, they think they know better. They think they know better than everyone else.
We kind of walk through like the bare bones criminal justice system from beginning to end. What is it like waiting for a verdict, both for you as the lawyer and for your client? And is there like a particular verdict that kind of stands out for you? And kind
Yeah.
of just like walk us through what that was like. Because that seems to me like the culmination of everything we just talked about comes to this one moment where like, the jury comes out and they have a verdict.
Yeah. I mean, it is it is an incredibly emotional experience, I think. The process of doing a trial in general, you're oftentimes working for 10, 12, 14, 15, 16-hour days. Your client is being woken up at like 3 a.m. every day, being brought to court because they have to be brought early on time. And so they have to, sometimes it's a far drive. So they're getting woken up early. So they're not sleeping. They're tired. They're listening to all these people talk about them, oftentimes with them not being able to respond. And so there's so much emotion and the stakes are always so high. I would say like it feels every time, and it has not gotten old in all my jury trials. I've done about 30 jury trials at this point. Your heart is just beating out of your chest, waiting for that verdict. And if I want to think about like a case that was like really meaningful, I told you about my murder trial, and that one was a big one. And I'll just reiterate it again that my client's life was on the line, literally. He wasn't going to die, right? But he was going to be sent to prison for the rest of his life. The judge doesn't have leeway, right? If he's convicted, it's life. That's it, period. And that period of waiting is anxiety it's so anxiety invoking. You can't think of anything else. And sometimes you're upstairs or sometimes you're just running around other courts handling other cases as a public defender and you'll get that text and from the clerk and your heart jumps and they're like, jury has a question. Then you go and the question is like, we want to hear read back of 5 witnesses. And they're like, oh my God. And then like you sit through all of that and then that ends and then you're waiting and waiting. And then the jury says, asks a question about the law and then you hyper focus on it. And you're like, what are they talking about? Why are they thinking this way or that way? And you're super anxious and trying to predict what they're thinking about. And then, you hear the buzz, and that means there's a verdict, and your heart is pounding, sitting in your chest. And I will tell you, you want it to go fast because you want to know, but the process of bringing the jury,
So slow. I've seen it on TV. Jeez.
sitting them all down, and just like the foreman hands the packet to the judge sits there, looks at it. You're looking in the judge's eyes because you want to see if they'll lose their poker face. Because you can tell sometimes the judge wants your client to lose. Sometimes they want them to win. Do they have a small smirk on their face? Are they like upset? Like you're just kind of analyzing that. Then they give it to the clerk. And then the clerk, who's like sometimes new, has to like take it out and then they say, in the case entitled 25 ACGH00, and you're just like, dude, can you just read the verdict? In the above entitled matter, we, the jury, in the charge of first degree murder, and you're just sitting there and your blood pressure is rising, your heart's beating out of your chest. And the moment they What I'm always listening for is the net, net, net of not guilty. And if I don't hear a net, my heart immediately drops. And, when they say the words, we find the above entitled defendant not guilty, and it's just like an explosion of emotion. It's so intense. I told you with my client, he burst out sobbing, digging his hands into his face and just crying uncontrollably. Sometimes you'll have jurors cry, like it's so emotional because these people have lived through this case and lived through the ups and downs and the emotions of what happened, and they're so invested. And so there is nothing in this life that is more emotional and intense than the reading of a verdict. I'll tell you, it's quite a feeling. It's quite a feeling.
I can tell how passionate you are about it. It's like living it through your eyes because you're seeing it from beginning to end and then the impact it has on your person. And having done, over 30 jury trials now, do you feel overall they get it right? What is your faith in the system?
I think for the most part, jurors are trying to do the right thing. I think that the jury selection process is a very good process, not just because it can weed out people who can't be fair, but I also think that it impresses upon jurors of how important these due process is, the presumption of innocence, and all these things. And I'd like to believe that jurors think that they are doing the right thing and they take the responsibility really seriously. I have lost a couple trials that I think that I shouldn't have lost, but the vast majority that I've won and some that I've lost, I think the jurors made the right choice. And looking back on it, I understand why. And so I think jurors they try to do the right thing, and they really work hard to get there.
Right.
Yeah.
Well, that's a lot of cool stuff you shared with us. And now you've entered private practice.
Yeah.
And so
Yeah.
begins the next journey for you.
Yeah. Yeah.
And how do people find you?
You can email me at omid@omidlawgroup.com, or you can go to my website, www.omidlawgroup.com, or you can call me 213-650-OMID. I always do free consultations. If you just want to discuss your case, even if you just have a public defender and maybe they're not like giving you the attention you want, I'm happy to talk to you about your case and do a consultation. So give me a call. I'm happy to
All
help.
right. Well, thank you so much. That was awesome.
Yeah, you
Thank
got it.
you.